So what can you expect when you separate and you come to see a lawyer? So you will probably have to spend about an hour with that lawyer to give background information. A lot of times people think that family law advice is straight across the board. Sometimes people think they should get a free consultation, but we start working right in the very first appointment because we have to give advice that's based on specific facts, and it is tailored to your situation. So there is no advice that I can just hand a sheet to people and say, here's how things are going to go for your family. So different issues arise and different facts are important, and only with spending some time with a lawyer can you go through all of that. So the lawyer will know what questions to ask so that you know what information is necessary. Without spending that hour, and sometimes it's an hour and a half and sometimes it's 2 hours, depending on the complication of the facts, so that the lawyer can assist you from that point. So at the end of first meeting with clients, we usually do try to identify those files that can be amicably resolved, and most times you will find that a lawyer will recommend to a client, let's write a letter to your spouse. And that letter I can just rattle off the top of my head real fast because I've done so many of them. It's usually, I'm in the process of being retained by your spouse. I understand that the two of you separated on, and we say a certain day. And what that does actually is it confirms the date of separation, because you can't separate without the other party knowing that you separated. So again, I'm being retained by your spouse in relation to your matrimonial circumstances. I understand the two of you separated on such and such a date. And then next would be is your spouse would like to try to amicably resolve the issues that arise out of the breakdown of your relationship. And to this end, she has asked me to write you to see if you're similarly minded. And then we usually then guide the person to say that our client's in the process of preparing a sworn financial statement and that they should get independent legal advice so that they know their rights and obligations, and we indicate that their lawyer can also assist them with the preparation of the essential financial statement. We then usually give a deadline for the other party to get back to us just to keep people accountable. We don't always stick with that deadline because we do appreciate that it might have a wait time to get in to see a lawyer, but so long as someone's taking some steps within that period of time, we hold off from starting litigation. Again, we look for people that are acting in good faith. On the other hand, where there's something really contentious or where the client has convinced me that there will be no good faith, we usually then just start with a court application. So starting with a court application, though, does not mean that you can't later resolve this on your own without court if the two of you can come to an agreement. So again, we really do try just to not damage families. We want to keep families as intact as possible, even though they've separated. We want goodwill between parents, especially when there's young children. And again, we want parties to save money by not having to litigate everything if that's possible. So oftentimes a letter, again, inviting the other to negotiate a separation agreement is the right way to go. I also told you that sometimes starting a court application right away is the right way to go. So where you expect a very contentious custody battle, for instance, or where there's been domestic violence, or where there's been somebody that has not been forthright with respect to their financial circumstances, I say, let's just get into court. We can sort that out later. So what happens if you start court? Where does it go from there? And what does that mean? So starting court, your lawyer will assist you in preparing an application. And that application gets sent to the courthouse and is issued and entered and becomes an official court document. It then comes back to a lawyer who will then arrange for it to be served on the other spouse. And by the way, I keep saying a lawyer will do all of these things. These are things that self-represented litigants can also do, but it is a difficult sea to navigate in terms of the requirements of serving and filing and knowing what forms have to be filed. For instance, if you're going to be starting a divorce application, you actually have to have a copy of the marriage certificate now in order to file with the divorce application. On the other hand, if you're going to be seeking financial relief, you have to include a financial statement, and that financial statement needs to include your past 3 notices of assessment. So we tell people to go to My Account for Canada Revenue Agency to get those notices of assessment when they come in at the very first appointment, because you never know if potentially you think you can negotiate this file and it turns out that you can't get that resolved by negotiation, and if there's a need to get into court quickly, a client has those documents in hand already. In any event, there is a possibility for people that haven't filed their taxes or have just filed their taxes and they're waiting the notices of assessment. They're not available to be given by CRA, but it takes an extra, we call it a 14B motion, where you have to ask the court, can I please file my materials even though I don't have my past 3 notices of assessment? I will diligently go about making sure that I get those, and I will provide it to the other party as soon as they're available. Also, complicating things, if there's any custody access issues, a parenting affidavit has to be filed as well. And the purpose of a parenting affidavit is to let the court know of your plan of care for a child and to give a court background about you and background about the person that you may be living with, or a help that you might have in the community with respect to care of this child, and identification of any special needs that a child may have and what your plan is or what is in place currently to address those special needs. This affidavit came into existence after there was a default case. So where there's a default case, someone would claim, in this case it was a mother claiming against the father, custody of their young daughter. And the mother got custody as of a right just because there was no defense to it. So got what we call default judgment. And sadly, this lady's daughter was killed by the man that she was living with. And in that case, the court had no information about who it was intended that this child would be living with. Did that person have a criminal background? If so, what is it? Did that person have any history of any child protection involvement in terms of other children that they've acted in the place of, or children that they have had? It asks about many things, including the spouse claiming custody or access as well. So that's a wrap-up of the documents that you would need to draft to submit to the court to have all issued, and then all of those documents would then come back to you to be served on the other party. Now, service for divorces has to be personal service, which means that a process server usually will have to hand over that application to the respondent, is what we would call that person. Now, sometimes we allow friends or other people to do it in the place of a process server where we anticipate it's going to be difficult to serve someone. Please note that the only person that cannot serve a divorce application is the actual spouse that is seeking the divorce. But we do try to keep it professional, and we do tend to use process servers. Another possibility is if the respondent already has a lawyer helping him or her, we ask as a courtesy if the other lawyer will serve the client. And not only is that something that saves your client money, but it also is a less embarrassing situation sometimes for the respondent who is receiving the documents. What we don't like is when a process server shows up at the home and there's children there and the parent becomes distraught. Again, we want to always try to avoid exposing children to adult conflict.